Good evening, everyone. I am Yusuf Hashmi from Team Taxmann, and I welcome you all in today's live webinar on PMLA uncovering the new duties for CAs, CS, and CMAs. But before we proceed, I shall take this opportunity to provide a brief introduction about Taxmann. We are the leading publisher on tax and corporate laws in India, committed to delivering the most authentic and enriching experience to our users. Our goal is to simplify the research and compliance of the legal community. Our unwavering dedication to this vision has driven us to work tirelessly over the past 6 decades, providing innovative solutions that help our clients grow their practice and take their tax practice to new heights. We have also developed and maintained the national website of the Income Tax Department with the assistance of our skilled tech team and the editorial. Now, everyone, please welcome our esteemed speaker, Mr. Biswajit Das. Mr. Das is a practicing advocate and the management partner of Juris and Juris, the lead lawyer of Team A and is the lead strategist of the Pre-emptive business risk mitigating strategic solution, both of which are the firm's unique and celebrated flagship services. Currently, he oversees 10 divisions of the firm covering 10 critical areas of law. He began his legal practice journey in the year 2003, directly in Supreme Court, criminal law to complete the subject art, covering every other branch of law, science, accounts, finance, economics, etc. He industriously imbibed while securing multiple highest professional qualifications in law, corporate secretarial, commerce, accounts, finance, and economics. His initial practice dominated the merger and acquisition, corporate, commercial, investment, and merchant banking, banking and finance, intellectual property, foreign exchange, and taxation branches of law. Welcome, sir. It's a pleasure to have you with us. But before we begin, here are a few tips for the audience. You will be on mute during the session. You can post your queries in the chat box provided. Your questions will be answered by the speaker either during or after the session. A copy of this presentation will be sent to you via email for future reference. Without further ado, I would request the task to address the audience. Over to you, sir. Thank you.
Thank you so much for giving me your introduction. And I convey my gratitude to the Taxmann for inviting me for this very important subject, which is very dear to me and it is close to my heart. Interestingly, Taxmann, even though is into, as we all know, I mean, during our education time also, and even in our practice period, Taxmann is one of the most important publisher of particularly confined to the tax areas of subjects, both direct tax and indirect tax. But of late, yes, the PMLA as an interest. In fact, this is my second time I'm coming to this session on the PMLA, and I'm extremely showing my gratitude to Taxmann for inviting me for this. And indeed, there cannot be a better medium than this particular publisher, which is though confined to the tax, which is related to the finance and transactional, domain of law. Certainly, they picking up the subject of PMLA. It certainly can have a better opportunity than this. And at a time, as we all are actually entering into a new era, according to me, that certainly the PMLA era is one of the most critical era. And the time has come for all the professionals, including the entrepreneurs and the business entities, including all individuals, knowing about this subject in threadbare, because this particular design law, I must tell you, has extraordinarily complex elements. And this subject, as we are entering into a discussion on your new duties for the company secretary, chartered accountants, and cost and management accountants. These are three premier most professionals, in fact, are recognized by three independent central statutes. And these professionals play a very, very vital role in the commercial and economic acceleration and development of this country. And now, only very recently, 3rd of May 2023, an executive notification issued by the central government trying to bring these three professionals within the territory of definition of your intermediaries, particularly the reporting entities, now regulated by your Prevention of Money Laundering Act. These professionals play a varied role under different statutes, particularly the statutory functions. And these professionals, knowing about these contours, particularly the contours of the PMLA, and the most critical and unique architectural design of this law is going to play an important role as to how the Indian judicature governs and administers this new law, though it is a law of 2002, but certainly we have entered into the most critical phase of the implementation of this particular law. Now, to begin with, let me tell you, before you understand your role, your new duties, obviously this is only a duty, not in return, you are not expected to get anything in excess except the fact that perhaps your services will be utilized in a better way by the Enforcement Directorate officials, including some of the reporting entities, the bankers, financial institutions, and so on and so forth. But as a professional, coming within the statutory obligatory duties is very, very important, because this is where your role under a statutory obligation under the PMLA will be key for implementation of this particular law. Till date, you are exercising statutory functions. Those statutory functions, like as a either you were operating the chartered accountants or the cost accountants, so they were required under different statutes to give certifications, some statutory audits, the company secretary, the compliances and all, under Companies Act, under Income Tax Act, under other different laws, they were given some kind of a certification requirement under statutes. But currently, under this particular law, with this amendment of May 2023, recognized you as those professionals, as the designated entities under the category of the reporting entity, like a bankers, like a financial institutions. You were to be extraordinarily cautious about your own clients and the nature of the transaction, the financial transactions that you carry out for them. And in that process, whatever the information, the financial transaction information that you come across, now those financial transactions will have to be reported back to the Directorate of Enforcement, the statutory authority, which is given the responsibility to administer this PMLA, as we call it as an ED, the Enforcement Directorate. Now, before you enter into that territory, I would always urge you that you, being one of the important cog in the wheel in the governance of different laws to commercial entities, the establishments, entrepreneurs and all, you have to know the entire contours of this particular law. Now, what is this law? If I may say so to you, that the contours start with the three broad parameters. One is the concepts of scheduled offense, the proceeds of crime, money laundering offense, the transaction, the intermediary and reporting entity. These are actually the statutorily recognized phrases, which has extreme importance, and they are extremely critical for you to ensure that you do not violate the law while you perform your statutory obligations under different laws. particularly the financial transaction related activities with respect to your clients. When you carry out those transactions, like buying, selling of the properties, immovable properties, or for that matter, the accounts, or your incorporations, or whatever, this kind of a financial transaction related activities which you undertake, and you is expected to comply this particular law, where the directorate informing them about the information that you collect as and when this particular demands the directorate would want you to service them, is the similar lines that the bankers and the financial institutions. Currently, though, the entire spectrum of your governance as far as complying how you will undertake this exercise is not very clear. Perhaps the government will come up with their KYC norms for you. For that matter, in fact, your institution will have a role to play, because in this case, the regulator for you three class of professionals are actually three different institutes recognized statutorily under three different laws. Now, they were supposed to prescribe the manner of collection of information, the manner of maintenance of records, the manner of furnishing the information, though broadly, by and large, they are already covered under the Chapter 4. But entire spectrum of your activity in terms of maintenance of these informations and furnishing of informations are not exactly clear. Surely, over a period of time, this particular law will come up with a better information as far as the government coming out with this notifications where your institutes to prescribe those guidelines for you. But the contours of the PMLA is important to note that in this case, the authorities are only 5 categories. The one is the central government, the second is your enforcement directorate, the third is the adjudicating authority, and then the appellate court, tribunal, the special courts. And then, importantly, the PMLA is a kind of an offense, is a kind of a law which actually prevents the money laundering offense, as well as prescribing the procedures for confiscation of the properties derived out of this particular offense of money laundering. And in that, if there is a scheduled offense, and as I told you, that the contours of the PMLA is very important to note. Otherwise, it will be very difficult to navigate yourself to be able to comply with this particular law. And the scheduled offense, if there is an offense which happens under different statutes, for example, whether it is IPC, whether it is Companies Act, whether different statutes, income tax, whether it is Customs Act, this scheduled offense, those offenses, once happens, any amount involved with respect to that particular scheduled offense is called the proceeds of crime. Now, therefore, the proceeds of crime is actually the starting point for the ED to initiate the entire process of whether it is attachment or whether it is prosecution for offense of money laundering. And therefore, the importance that the transaction, that since this is a money laundering offense which relates to that of the proceeds of crime, that is a proceeds, that means anything that is derived out of the offense of money laundering, and that proceeds of crime in possession or in use by anybody will be committing an offense of money laundering. And therefore, this is an offense which is related to the transaction. And mind you, this particular law has got 2 additional consequences apart from that scheduled offense. While one scheduled offense happens, the consequences out of that scheduled offense can have 2 additional ones. That is one, there is a money laundering of the proceeds of crime, being in possession or being in use of this. And second is the prosecution over that proceeds of crime by way of attachment and confiscation. So therefore, with a one action, this is such a kind of a law, such a unique law, for a one action of offense under any special statutes can lead to additional 2 consequences. That is, one is a money laundering, and second is your confiscation processes undertaken by the government for the purpose of getting it back away from that of the criminals, or for that matter, the money lender. So these are the 3, 1 action and 3 consequences. This is such a unique law. That's number 1. Number 2, in the entire process, please remember the critical and most unique architecture about this particular PMLA is here. It's important that this is such a kind of a law which begins with a possibility of the ED writing that I have reasons to believe. Means if the ED writes, this is such a kind of a unique nature of law where the ED has to write that everything becomes the proceeds of crime and everyone can become the money lender. However, they're expected to operate with the responsibility. But then since it is a transactional issue, certainty, in fact, in practical sense, may not be that easy for the ED to come to a conclusion. But then they have the protection under the statute for taking these prosecutions, though this particular legislation came from that of your international convention and the resolutions which was passed by the United Nations Assembly for preventing the money laundering broadly from that of the organized terrorism and the drug money. But ultimately, if you see the current legislation, in fact, the PMLA, which came in the year 2002, enacted by the government of India then in the India regime, but it was actually enforced in the UPA regime in 2005. Interestingly, this particular legislation came after 10-12 years from the first resolution adopted by the United Nations Assembly in the year 1990. And this 2002 enactment came only after the 9/11 attack to the Twin Tower in New York. So the legislation which was enacted to achieve a particular objective, and that is why we call it as an objects and reasons of this particular statute, it starts with saying that the sovereignty, in fact, the financial system, to protect the financial system, the integrity and sovereignty of the nation. These are the three objectives on which this particular legislation was enacted. And that enactment of a legislation whose foundation starts with the authority, AD, writing down with respect to a proceeds of crime, saying that I have reasons to believe that this proceeds of crime is an offense. This is a proceeds of crime. So with that, everything that I always call it like this, that this is such a law where you can declare anything and everything as a proceeds of crime, provided the ED has to write, I have reasons to believe. That is number one. Number two, the moment that happens, anybody in possession or anybody in use of that will be an automatic money launderer, because I have reasons to believe, again, the ED officers, the authorities has to write it down to initiate the special court prosecution of offense of money laundering. Though I call it with this level of sincerity, in a sense that as we see that practically, in fact, we are actually handling many of the similar matters, where even for a developer, even for a builder, or for that matter, a mining concessioners, or that the bank default cases, a mere default turning into a fraud declaration by the bank, and then that particular fraud can lead to the money laundering consequences initiated by the ED. So therefore, one act of alleged illegality under a special statute can lead to two consequences. One is a money laundering, and then the prosecution for confiscation of that proceeds of crime in your possession. So in that sense of the matter, if you see it in totality, you will see that this law as it stands today, this section 3, which is an offense of the money laundering, it has to go through the test of the ED writing down averages. So everything on earth, whether today or tomorrow, everything on earth can be declared as a proceeds of crime. Similarly, everyone in the world can become declared as a money launderer. And let me tell you, the limitation, when it comes to this, limitation also an important element is this. In this case, since there is every millisecond a proceeds of crime in possession or in use are a new cause of action for a money laundering, therefore, there is no limitation per se. So this is the level of seriousness with which I beseech all my colleagues to understand this particular branch of law, that it has no limit, as opposed to any other kind of offense, whether it is IPC or any other special law. There has to be an act. There has to be a trigger. But here, the trigger is a certificate by the ED writing down with respect to a transaction as a proceeds of crime, and then the entire things can start with respect to 2 additional consequences. And that's the nature of this particular law. And let me tell you, even in this particular law, anything and everything can be treated as an evidence. And it is for the judgment on the part of the ED to decide which transactions, which entries, which things, etc., they will treat it as an evidence. And then they can also force anybody to give the evidence, because under the law, every entity or actor or the player in any kind of a chain of transactions can be treated, can be enforced, can be forced to get given evidence against the alleged act of offense of money laundering. And then, interestingly, in this case, the moment that certificate comes from the ED, then the presumption of innocence as a statutory policy doesn't exist today in this in this nature of the offense, where the burden of proof shifts from the prosecution to that of the accused. That's the architecture of the PMLA as it stands today. And therefore, now the professionals, whosoever are part of this entire transactional, because these are, as I told you, this is an offense related to the transaction. Now, transaction, it can be a mere bank entry, it can be a actual sale purchase transaction, it can be a share purchase transaction, it can be a bank loan advances, it can be extensions of lending, borrowing, gift, any form of transactions. And therefore, the professionals in part of this transaction, in the stream of processes, wherever their role comes in, they are, to this notification of May 2013, they have shown them to be a reporting entity to comply with respect to maintenance of the transactions, informations, records, also reporting to that of the ED as and when it is demanded, sometimes on periodical notes, sometimes. But then let me tell you, as compared to the other form of reporting entities, like the banks and financial institutions, they have an entire structure, they have entire mediums. But a professional, a company secretary, whether it is individually or through firm, and carrying out a transaction on behalf of the client in the course of profession in relation to the transactions, designated transactions. Now, I think in the next slide, I think that is a next, yeah. This is what is the notification of 3rd of May 2023. And in this particular, this notification, what they have done is that they have brought in the three classes of professionals, the chartered accountant, company secretary, and CMA, into this fold of reporting entities. For the nature of financial transactions in relation to the designated activities, which is shown here in the 2, when they talk about the immovable property, any buying and selling, whether it is money, securities, other assets, management thereof on behalf of the client by these professionals, because they do the professional services, they provide the professional services where certifications, audits, compliances. Besides that, also they undertake some of the services which is beyond the statutory limits. And when they undertake those exercises, also they are being treated as these in the course of the profession. So therefore, beyond the statutory duties which they undertake under different statutes, they also undertake some professional services, not of the nature of the statutory nature, in that whenever they come across with any financial transaction, either they carry out by themselves or on their behalf, then in that event, these are the nature of the designated activities. If that financial transaction relates, then they are expected to follow the duties, the obligations under the statutes to maintain and report. Not only they maintain and report, in fact, in that exercise also, let me tell you, I think next slide, you can turn to the next slide, Devesh. Next slide, Devesh. Am I audible? Yeah. No, not before that. Before that. And the next slide. Role and relevance. Yeah. Now, you see, this particular law, as we all know, is trying to tackle the menace of money laundering. But then, even though it began with a mandate as a political declaration adopted in the United Nations General Assembly, the political declaration is that there is a menace of money laundering where swaths of money is getting routed, get from black to white through syndicates, organized crime with cross-border implications and impinging into the financial system of that particular country. While that was the original objective, subsequently it entered into the space and sphere, as you know, the scheduled offense, as we call it, as a prime offense under which any proceeds derived out of it or obtained therefore is treated as a proceeds of crime, and thus the consequences of money laundering and other exercises is undertaken in this law. But then with the legislations as we speak, the schedule to this PMLA is added on, and currently there are about 31 statutes are added. And in this, if you see in totality in the constellation of these legislations, according to me, you don't need any other legislations to be inducted. To be able to capture all possible transactions being possible, all transactions being possible money laundering offense. And because as I told you, anything can become proceeds of crime, anything around us, anything. You talk about anything. Because an X amount derived out of an offense of fraud, that X amount is the proceeds of crime. So fraud is a scheduled offense. The proceeds of crime, that is amount derived out of the fraud, that amount being the proceeds of crime, anybody using it, concealing it, possessing it, acquiring it, and then tempting it or declaring it as untainted property is a money laundering. So therefore, the very fact that a proceeds of crime is in your possession is a possible that it is a case of, because your mens rea as to whether you have consciously concealing it, whether you are using it with ulterior mind of using it out of a tainted money and declaring it as untainted money, in that event, that is a matter of trial. And therefore, for the prosecution to undertake an offense of money laundering prosecution and then consequent attachment and confiscation of the proceeds of crime, it's just for the asking, it's just there. The authorities, as you know, these are all transactional issues with every millisecond giving rise to a new cause of action. It is virtually impossible to certify this way or that way, except a possible judgment on the part of that particular enforcement directorate officers forming one opinion or the other. For example, today, a bank loan being claimed to be defrauded. I mean, suppose there is a default of a bank loan and the RBI guidelines is exercised by the bankers to declare it as a willful default of the fraud. The moment that happens, that fraud is a scheduled offense and the investigation can be carried out by the CBI. Then in that event, the moment that comes in, then the ED can comes in. And then the special court can combine both these offenses, this trial for the scheduled offense as well as the money laundering, and then they carry out the two different classes of offense prosecution. And while at the same time the proceeds of the crime, that means anything derived out of that particular offense of fraud, that means whatever the loans, advances, any amount for that matter, they will all fall under the category of the proceeds of crime. And then that will be also prosecuted for your confiscation proceedings. Now, what I am saying is that this is the level where this particular law can go. This is the level the EDs can go, that theoretically, everything proceeds of crime. Theoretically, everyone money launderer. Now the question is, how do you tackle these issues? In fact, we have also, I am dealing some of the matters personally, and I realized, in fact, some of the offences under the mining law, they are prosecuted under Income Tax Act, they are prosecuted under the NGT, National Green Tribunal Act, for a polluter's pay principle, and then also it is being prosecuted under this PMLA, even though the entire 100% is paid back to the government, pursuant to direction from the Supreme Court. Now, these are the officers, these are executive officers, do not have much of the training on the law side of it. Certainly, they are being advised by their own people, no doubt. But the question is, how do you tackle this kind of a law with three consequences for one action, and then whichever those people are part of it will be can be summoned under Section 50 during an inquiry, asking you for any transactions right from 20,000 above amount. Now, I found out interestingly that here each one of us have a role. In fact, the virus challenge upheld in the Supreme Court in the Vijay Madan Lal Chaudhary, there are serious issues still remain. Some of the components have been referred to the higher bench or different bench for review, but then there are many declaration of law on some of the virus sections, some of the sections virus challenge, and many of the relevant arguments are not being put before the court, leading to a situation where the court only found this legislation being purportedly correct law, and on the ground that there are oversights, and there are safety measures that are already there to handle this matter. On the contrary, many of the relevant provisions, to the extent saying that, for example, a ordinary offence under the IPC, say 420-405, fraud and cheating. Now, in that, a local police has the jurisdiction. Now, the moment the ED comes in, the entire jurisdiction of the local police goes, and it goes to the central agency. Now, the central agency, if you see the entire spectrum of the law, if you see the entire architecture of the law, it is every section, the central government is empowered to either make the law, to make the rules or regulations. And that is how the government of India, through different notifications, executive level, have come up with the rules, and that rules is now acting as a legal to this particular, and that is how this particular law has expanded. And now, with this notification, even the company secretary, chartered accountant, and the cost and management accountants, they have come within the net of this particular legislation, where they are asked to provide this information. So unlike the ED, which is given the protection, the nature of the protection for because Section 62 talks about the penalty for vexatious initiation of the your money laundering prosecution. But in that event, the only way by which they will be prosecuted, provided I have reasons to believe, as it is not recorded in writing before initiating the process of money laundering. Now, in that sense of the matter, I suggest I found out that the amount of the protection of these agencies, the authorities under the PMLA, similar nature of the protections are not given to either the company secretary, chartered accountant, CMA, or other reporting entities. Though the bankers, financial institutions, and other intermediaries, they have other regulators, and they are prescribing their regulations as to how they will manage their accounts, the transactions, reports, etc., and for which, of course, the Government of India is also coming up with the additional notifications, but similar notification likely perhaps the institutes will have to come up with to be able to make that notification workable. And this particular legislation is working like a Lego, with different professionals and different entities, different intermediaries are given the responsibilities to come up with that. Though the intentions behind this legislation is no doubt is very human. Originally, though it is intended for a cross-border organized crime, it is extended to the financial transactional issues, it appears that as of now, a lot of big fraudsters and particularly financial frauds, etc., are getting caught in this. But theoretically, and of course, as we go on, as we move on, as we experience, this particular legislations has within its fold taken into every petty transactions within its fold. In fact, the nature of this law is such that the amount of the protection that we get for the enforcement directorate, similar kind of protections is not there. But yes, for furnishing these informations to the ED, definitely there is a protection. In fact, Chapter 4 talks about protection. That what is that protection? That no civil and no criminal prosecution can come against these professionals while they furnish this information, some class of information. But the point is, you are hired by the private organizations, business entities, and the entrepreneurs to provide one nature of professional service that is called your statutory functions. The other nature of professional services that you can find is not non-statutory in nature. So while, as you know, the nature of the profession that we undertake, particularly these three classes of professionals, the nature of the services is mostly a statutory practice. And for a non-statutory practice, which is handholding, which is taking, complying the regulations, etc. in compliance, they are doing a secretarial practice. So in that nature of these services, this is not purely falling within the fundamental right nature of practices, which is protected under the Part 3. But here, these are the statutory practices. Out of the statutory, non-statutory practices, as I told you, they will be all under the statutory obligations, under the PMLA. And then you were expected to undertake a high level of due diligence. And in that event, when you will be engaging, then you will be engaging only to the professional duties without non-professional interest. Unlike the bankers and financial institutions, as part of a system, they were to maintain those records, and they, under the banking license, the RBI license, they were supposed to provide all those information. But unlike that, the CS and CMA, who will be maintaining these information, will not be even provided the nature of remuneration that they would need for the purpose of even for the maintenance of these records and all. These are to be maintained at your own level. And in that event, you will be only providing these information as part of the statutory obligations. And this, as a mandate, you have to do it. If you don't do it, then there is a prosecution against you. So, and for entrepreneurs, when you have these professionals for the purpose of the statutory functions, you have nothing to say. But certainly for the non-statutory services, it is your privacy, it is your rights, it is your sphere of protections that is needed. But here, this is such a law which under Section 50, through an inquiry, they will undertake. In that, through summons, they will be asking all kinds of transactions, all kinds of, including 20,000 and above transactional informations. Apart from the fact that the entire network of our properties, whether it is within your core level or within the peripheral level with your family, friends, etc. So all nature of transactions they would be needing under Section 50. Unfortunately, this Section 50, which talks about if you are not providing these information to the ED, then in that event, you will be forced, you'll be prosecuted for that, for a non-cooperation and non-furnishing of information. So even the Article 23, which talks about the self-incrimination, that also doesn't apply. So therefore, the time has come, as I began by saying that the time has come, that here is a case where a legislation has come which treats everything as possible potential proceeds of crime and everyone as a possible potential money launderer, that every one actor in the process have a role to play. And in that, how do we achieve that? The question is, for example, the legislation, the concepts of the presumption of innocence for that matter. This is the bedrock, or the basic principle on which the entire edifice of the criminal jurisprudence stands. That till the man accused of commission of an offense is proven guilty by a prosecution, he will be innocent. Now, this presumption of innocence as a concept is actually embedded in our CRPC and different legislation, the legislative principle. But then this is the only law which has inverted. Of course, there are other laws like Kofi Kosa and other laws are there where the presumption, the burden of the onus of to prove your innocence is also prescribed in some of the legislations. But if you see in totality, this is a one legislation which has inverted about 9 principles. Like, for example, the entire prosecution will be through CIR, which is a concealed document. It is not to be made available to you unlike the FIR. So you would also not be knowing exactly what is the nature of the offense alleged. So scheduled offense. So for that matter, so this is where this particular legislation singularly has the constellation of the inverted principles on its totality is making it extraordinarily impossible to tackle. And that is the reason, and according to me, perhaps one of the culprit is the rules of interpretation that we all know. The rules of interpretation that we use as a language of law in understanding and interpreting the statutes is certainly not something helping currently. And that we need to understand and innovate a new jurisprudence. A. B. There has to be an errorless approach. How do we achieve that errorless approach? In a sense that, let me tell you, for example, the Vijay Madanlal Chaudhary judgment, where it tries to, declare to the extent saying that there is an adequate safeguards, and then to the extent saying that section 62 is there. But in fact, section 64, a provision which says that the cognizance of section 63-64 is there, which the central government is in a way, if you see it in a constellation way, the provisions which are there not brought to the kind notice of the Honorable Supreme Court to be able to come to a holistic opinion about this virus challenge is something for us to judge, for something for us to present, because after all, these are our institutions. It is our responsibility. Our ecosystem is getting disturbed for an attempt to find and use the possibility. For example, we are wanting that all offenders, the transactional offenders, should be caught. Now, how do we achieve it? Is this the design, the legislation that is tearing us, the PMLA? Is it really achieving that, or is it capable of achieving this result? Because the fact is, the moment there is a recording to the effect that I am resisted to believe by the ED to initiate the prosecution, the owner sits on the other side to disprove it. Now, the question is, how do you disprove it? Suppose, for example, you buy this product and this is declared as the proceeds of crime by the ED. Now, how do you disprove it? Because every millisecond you must have bought it from out of many sources of transactions. Which transaction is linked to it? Which transaction is not linked to it? Can be correlated. And in fact, the colleague of mine who once visited to in one matter, the official from ED said that in 2017 they brought the first conviction. I say that no, if you begin this exercise, if you really apply this law in a true sense, then there has to be 100% conviction. How? Because it is a transactional issue, it is an entry-based issue, it is an entry-based allegation of offense. If there is a scheduled offense, anything derived out of it is a definitively proceeds of crime, and the property or the value of that property derived out of that proceeds of crime is certainly is in possession of somebody, means it is an offense of money laundering. So there is no escape route. Money laundering, the moment there is a scheduled offense, there has to be a proceeds of crime if that is what they alleged by the ED. It's impossible to actually dislodge the presumption because the onus is on you and it is transactional in nature. So therefore, the best way to deal with this particular branch of law is first try to understand it in threadbare in every possible angle and see the law in totality, number one. Then engaging the society on a clarity path in the sense that leave no ambiguity in understanding this law. And believe me, there are different contrapositions, there are different provisions which actually operate in contradicting another provision. If we can draw that constellation, unfortunately, I don't think I have enough time to really demonstrate it right now to be able to show to you that how different provisions can be shown to contradict each other. And in that sense of the matter, we have a role to play and every professionals have a role to play. Because after all, finding a better discourse is our responsibility to make our own professional and personal ecosystem safe. It cannot be so that my offense is dependent upon the certificate of somebody and not dependent upon any physical action, but dependent upon a transaction. So therefore, it's like dealing with the virus challenge of the PMLA by referring to the old jurisprudence. It certainly is not helping us either. And then in the sense that we can develop the new jurisprudence where it is the responsibility of all the professionals to find them. For example, intentions of your doctrine called intentions of the legislature. I read a text, you read a text. You say this is my interpretation. The other says you say this is my interpretation, and then you read it as the intention of the legislature. After all, the court will read it and will formulate its opinion. Does it have any bearing? Do we even need to understand what the intentions of the legislature is? It's basically if we have a fundamental principles like this. For example, in the criminal jurisprudence, we know that if on a given text of law, more than one plausible interpretation is possible, that plausible interpretation which is favoring to the person accused of, it has to be applicable to him. After all, a civility in the society achieved through a law has to be seen from the perspective of the person who is getting governed in that particular law. It's not the person who is governing will decide your criminality. Yes, they can accuse as part of maintaining the tranquility in the society. They may accuse you as an offender, but at the end of the day, the court will come to a conclusion as to whether you are an offender or not. What the court will come up with an opinion to the extent saying that if this is a plausibility or not. So therefore, I say that the fundamental principles of law which we are applying these days, the whole jurisprudence developed 100 years back, 200 years back, is certainly not giving us a tranquility when it comes to application in the court of law. Now, that also can be a measure for us to assist the parliament. That also can be a measure for us to executive and to the courts to navigate them. And coming back to the professionals, like chartered accountant, company secretary, or for that matter, though thankfully the lawyers today is not covered under this as part of the obligation under the statutes to report to the ED. But then these are the three professionals who are involved in the entire process of business process, compliance, and many other facets of operation of a business. And in that event, if they are being brought in within this, though there is a protection is provided under the statutes only against the prosecution for civil and criminal prosecution. But I don't think it is enough as safeguard is there for these professionals to be able to protect themselves from the vagaries of these particular statutes. Because once the problem is that the trial in India, we are still being governed by the 1860 Evidence Act. We are still being governed by those old laws of criminal process. Now, with a new design law coming in our way on transaction, what I least expect that my colleagues, my friends should look up to the way forward to find the solution from this while helping the government, including our institutions, to achieve their common objective. And I hope, in fact, I'm ready to answer any question. Broadly, I have covered all these points which we wanted to convey. And is there any query on this, any of the points that I have flagged here? Is there any chat? Is there? Okay. Well, there is a question says that I'm a chartered accountant working with a CA firm. Can I be the signatory for my client's bank account? Well, let me tell you, there is no restriction that you are not supposed to do what you were doing it till date. The only thing in this process is that the moment you will be a signatory for your bank, your client's bank account, because after all, let me tell you, the bank account is of your client. You are a signatory for what? Are you a power of attorney holder to maintain that account? Are you a signatory as a introductory account holder? Are you introducing that client to open a bank account? Now, in each of these activities which are non-statutory in nature, as part of your profession, you can undertake. But then the moment you do that, then you will be definitely coming within the regulatory system of the PMLA, where if at all, like for example, there are triggers, like if a cash transaction is 10 lakh and above. Similarly, there are a transaction. So there are trigger points which you have to maintain and you have to report to them. So this is how, I think I have answered this question. You can become, you can do the necessary provide professional services. In that way, there's no problem. What is the limit for the KYC as defined under the law applicable to the companies other than financial institutions? And sorry, what is the limit for the KYC? I'll tell you that currently, if you are asking it from the point of view as a chartered accountant, company secretary, and CMA, there is no clarity as of yet in terms of what the KYC limits. In fact, the existing KYC norms, which is prescribed by the RBI, is only with respect to the banks, financial institutions who are governed by the RBI through the licensing regime. Now, the KYC for other professionals, that will be likely to be prescribed by the respective regulators, like as I told you, perhaps in this case, Institute of Company Secretary, Institute of Chartered Accountants, and the Cost and Management Accountants. Is there any mandatory reporting? Well, in fact, there is, as I told you, there are trigger points, as we know currently with respect to these banks and financial institutions for which the provisions are already prescribed. Like, for example, 10 lakh and above cash transactions, for that matter, in the maintenance of records rules, PMLA 2005, it prescribes 10 lakh. Whether if it is within a period of, if there is a series of cash transactions running into within a month more than 10 lakh. Similarly, there is some suspicious transactions. So what they have done is that they have defined what is the suspicious transactions. They have also defined what is the specified transactions. Specified means limit-based transactions. In that event, you have to report, you have to maintain it, and you have also to report it. Suspicious transaction, you have to report it within 7 days. And also when, as and when the ED will invite your a particular information in respect to a particular client, then you have to give that information. Let me tell you, the next question is, can PMLA apply to a situation of crime without involvement of money? Well, let me explain you. If there is a scheduled offense and there is no money involved in that, means there is no proceeds of crime. That means no property, no value derived or obtained out of that scheduled crime. Then there will be no proceeds of crime. Since there will be no proceeds of crime, there will be no concealment, there will be no projection, there will be no possession, there will be no use, there will be no acquisition, and thereby there will be no money laundering. And in that event, PMLA shall not apply. But the problem is whether money is involved or not. Issue is that money is involved or not, it is a subjective satisfaction and claim on the part of the ED to write, I have resistibility. The moment I have resistibility, the ED says, because if there is a scheduled offense and ED comes to a conclusion that yes, there is a proceeds of crime, the ED can always begin the exercise of investigation. And the moment that happens, the PMLA triggers. Because the trigger of the PMLA is not the commission of offense of scheduled offense. The trigger of the PMLA is claim on the part of the ED that I have reasons to believe. So that's the problem. I mean, that is what I am repeatedly flagging. It is not an actual physical action, but actually the certification, opinion given in writing by the ED to say that I have reasons to believe. Then, next question, will audit services where certain facts emerge which directly impact PMLA, then will it result in reporting? Well, yes, whenever during the course of the audit services, currently the definition of section 21 SA, which was introduced, which were expanded through this amendment and through notification of 3rd May, they say that the financial transaction in the course of profession, during the course of the profession, and related to the activity of buying, selling, etc. Now, what you do is that during audit services, when you find out those financial transactions being suspicious in nature, being specified transactions, as I told you, in that event, yes, you are expected to maintain that particular transactions. You are expected to maintain the information in the record, and you were expected to report it as and when so demanded by the ED, unless through your regulator, a new regulation or provisions are prescribed for you to report it in a periodical manner. So currently, as I understand, as the law stands today, the audit services, anything that you find regarding the financial transaction, was supposed to give that and maintain that. Whether the reason to believe is required to be proven prior to initiating a payment, not at all. What they have done is that the moment that the ED comes to a conclusion that I have reasons to believe, he will record it and he will forward the reason, order, and material on the basis of which he comes to this conclusion to the adjudicating authority. That's the test. So, because money laundering offense is a consequence to the proceeds of crime, so the trigger point is always the proceeds of crime. So therefore, the moment that particular finding comes that I have reasons to believe, that's finding in writing. Second, the material on the basis of which he comes to this conclusion. Third is the order of search, seizure, or attachment, or whatever it wants to trigger, whether it is under section 5 or whether it is 16, 17, 18, etc. That will be given to that of the adjudicating authority. So that is how the checks and balances which the Honorable Supreme Court in Nizam Adalal Chaudhary found to be sufficient. On the contrary, I have a completely different line of thought. Unfortunately, is not true to the kind notice of the Honorable Supreme Court, and that is it is, as I told you, it's a transactional in nature, and the moment that transaction is found to be so as a proceeds of crime, as per the estimation and assessment on the part of the ED, PMLA comes in. And the local agencies goes, central agency comes, and then the attachment will happen. I'll tell you one interesting aspect. For example, we are actually suffering these offenses, whether it is cheating, fraud, or anything. When my property is taken away, at best we can go to the court for prosecution for that person under IPC 405 or 20. But regarding the recovery of that fraud amount, proceeds of crime under the ordinary law, I have to go to the civil court to recover that. But the moment the ED takes cognizance of that, the government will recover that. And then the government, then I have to, the question is, since it is a proceeds of crime recovered through attachment and confiscation by the central government, then I have to go to the central government. So that means there is a disparity also in the nature, in the manner in which different class of offences are prosecuted in India when it comes to the PMLA and when it comes to other than PMLA. So that's how it is. This particular law is panning out, and interestingly, as we speak, this particular law is getting complex as we grow, because interestingly, the Honorable Supreme Court, while upholding the Section 45 of the PMLA, that the twin condition, said that yes, this law is good because the court has a power to grant the bail. And let me tell you, when the Honorable Supreme Court said that yes, it can grant the bail on the argument on behalf of the ED, saying that the court has a power to grant bail, while it can only grant the power grant bail when it will come to a conclusion of that yes, the person concerned has not committed an offence of money laundering. That means at the time of granting a bail under Section 45 as a statutory measure, the court can only exercise the power to grant bail is when it will have to certify that yes, there is no offence of money laundering, nor he will be committing offence of money laundering in future. Now that is a finding always, as we know, as part of a criminal process system in the country, that it can only be decided at the stage of final discharge or final conclusion with the trial. It cannot so happen that at this stage only you can do it. But then when it comes to a statutory exercise of power by the different courts, in some matter the ED challenged the Supreme Court to the extent of saying that how come the court will grant a bail with a conclusion and finding that the person concerned, the accused person concerned, has not committed an offence of money laundering. So this is what is the your discrepancy or dichotomy, as you say, is we are witnessing. And every now and then, when we innocuously apply the criminal process in CRPC into the IPC, we will get the outcome differently. When you try to do it, apply those jurisprudence, we tend to get confused. In fact, recently the default bail as a concept, when it was decided by the two bench of the Honorable Supreme Court within a span of 15 days, one bench says that no, this is a statutory right and you have to exercise statutory right as per the conditions. The other bench subsequently within 15 days with the one honorable judge being common to the two bench of the Supreme Court within a span of 15 days completely give a 180-degree a completely opposite outcome. And by arguing that it is a fundamental right, the default bill is a fundamental right. And on mentioning by the ED before the Honorable Supreme Court, the Honorable Chief Justice of India has stated that particular, in a way, indirectly, not directly, but indirectly has stated the effect of that particular judgment. So I'm saying within a span of only 20 days, three benches are giving three different opinions, and that too with respect to this kind of provisions. On the contrary, whether you call it as a statutory right, as a default bail, or you call it as a fundamental right, as it is said in the subsequent judgment, in either of the way, it is not a correct argument to say so whether it is statutory right or fundamental right. After all, the exercising power by the Parliament under the exception to Article 21, when enacted this Section 41, and it has locked up one's natural right, it has to unlock it, and that is how it is unlocking in 167(2). So therefore, it is to be argued that it is actually the duty, the authority putting somebody behind the bar in exercise of power, like police exercising power under Section 41 of the CRPC, arresting somebody, has to release it one day, And that one day is 167 too. So that's a duty. It's not a right of me. My right is independent of this. My right pre-existed exercise of power under section 41. If my right also exercise, my right exists there. Only for a limited purpose, the authorities are locking me up. And that unlocking only has to happen from the government. So I'm only saying, when we talk about developing new jurisprudence, we need a little mathematical way of presenting the court so that the court will feel more confident to get that judgment, to get that desired, deserving relief, than giving us a confused outcome, which, as in this case, in default bail case, the same judgment didn't see the day of the life of more than 4 days. So, well, these are all, we all are dealing every day in the court, but certainly the role of all the professionals have gone up with the responsibility. It's staggering. I think, I hope we have answered all the questions. Can PMLA apply where there is a crime but no money involved? Will audit? I think we have answered that question.
Yes.
We have answered, right? Anything else to me?
So these are questions.
I think all answered. Do we need to answer the other questions? Is there any other questions coming up?
No, sir, there seems to be no further questions. So I would like to conclude this. My sincerest thanks to you for your outstanding presentation and a clear and concise explanation of the subject matter. And I greatly appreciate the effort which you have put into making this session a success. I would also like to express my gratitude to the participants for their cooperation. Your valuable contribution are a vital component of the session's success, and we could not have done it without. Although we have attempted to address the questions raised during the session, please feel free to send any additional queries in writing to sales@taxmann.com. Thank you all again. We look forward to presenting another vital topic to you soon. Until then, take care and have a wonderful evening. Thank you.
Thank you.